talk as we're going to talk about from victim to accused, the Priya Ramani case. With the senior advocate, Supreme Court of India, Ms. Rebecca John, who's Priya Ramani's lawyer. In the wake of India's Me Too movement, journalist Priya Ramani spoke up about how she was harassed by MJ Akbar, journalist and politician. Following this, MJ Akbar sued Ramani for defamation. Thus began, a long journey of a victim being turned into an accused. And recently, in a landmark judgment by the court, Priya Ramani was acquitted of the charges of defamation. But this journey was not easy, and we just get into that. And it was filled with ups and downs and challenges for Priya, and fighting by her side and for her. We have the senior advocate Rebecca John, and today's session, we have Sipping Thoughts co-founders Meeta, Gutgutia, and Sukirti Gupta, and Payal Chawla, who's the founder of JUSCONTRACTUS, which is an all-women law firm, in conversation with Miss John. So let me, before we get into the conversation, please allow us to introduce the two special guests that we have joining us today. Founder of Just Contract Us, which I just said that is an all-women law firm. Payal Chawla has a Master's of Law degree from University of Chicago and is also an alumni of Faculty of Law, Delhi University. Professionally, she has previously worked as in-house counsel with Coca-Cola and many other companies, and she was also a partner with HSA Associates. Payal Chawla has also been named as one of the thinkers to watch out for by Forbes India. She has also served on the Judicial Commission headed by Honorable Justice Usha Mehra in the Nirbhaya tragedy case. And in addition to her legal practice, she has a deep academic interest in arbitration, and she writes regularly for reputed publications. Please allow me to introduce the special guest today, Ms. Rebecca John. Designated as a senior advocate in 2013, Ms. John enrolled with Bar Council of Delhi in 1988 and has been practicing exclusively on the criminal side in the Supreme Court of India, High Court of Delhi, and in trial courts of Delhi for more than 3 decades now. She has conducted a wide range and argued appeals dealing with offences under Indian Penal Code, Unlawful Activities Prevention Act, Prevention of Corruption Act, and other special statuses. She is a member of the Internal Complaints Committee of the Delhi High Court dealing with complaints under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. She is also a statutory member of the Delhi High Court Legal Services Committee. So let's get into the conversation now, and starting the conversation with the first question, we have Meeta Gutgutia. So ma'am, please take it ahead.
So, hi, welcome, Rebecca. Thank you for being here. Hi, Payal. Law is a very, very heavy word for like half the terminology we don't even understand. But let's start from Priya Ramani's case because it's been a milestone case. Not just because it was Priya Ramani's case. It's a victory for Me Too movement. So I was listening to Priya and she said, I thanked Rebecca for believing in her and the wider cause, which says all. So I want to ask Rebecca that please tell us what this the whole case about, because we know that she was a victim and from victim she became an accused. So the battle was double. It took time. So we want to understand from you.
So as you know, the India Me Too movement started in October 2018. As a consequence of that, many women from different walks of life, different professions, began to write on Twitter and other social media platforms and online publications about their experiences in the past with their male bosses. The Me Too movement had begun in America a year earlier in 2017. On 8th of October 2018, Priya Ramani wrote on Twitter, she published a tweet where she called out her first male boss for sexual harassment. And that subsequently led to a criminal complaint being filed against her in a Metropolitan Magistrates Court in Delhi by the person she had accused of sexual harassment, Mr. Akbar, where he claimed that she had defamed him by making those allegations against him and that there was no basis for those allegations. That, in a sense, was really her tryst with the law. She was summoned as an accused by the court of the Metropolitan Magistrate, and thereafter she stood trial. While it was a defamation case, this case was of monumental importance because it was interlinked with many other issues, namely freedom of speech and expression, the right of a woman not to be sexually harassed, and the right of a woman to have a safe working environment. And as we will go forward in this discussion, and I'll be speaking about it, her truth. Priya Ramani pleaded truth as her defense and said that whatever claim she had made against Mr. Akbar actually happened, and that she was willing to lead evidence to that effect and prove her innocence.
I will take it up from there, Rebecca. There were a lot of women that came up and kind of said, okay, you know what? They made allegations. And they were far more severe, far more egregious than the ones that were made by Priya Ramani. Then why only was Priya Ramani, why was she the only one singled out in this defamation case?
In fact, in the evidence we led before the magistrates court and in my final arguments before the court, this was one of the important points we raised, that Priya was selectively targeted by the complainant and prosecuted, even though very, very many women had made extremely grave allegations against him. This was a question that was for him to answer, but there was no answer by him. And we consistently, even during my cross-examination of Mr. Akbar, I did ask him this question as to why he had not filed similar complaints against other women. Now, while it is the right of a person to choose who he files a complaint against, but there is sufficient law in this country which says that if you decide to file a complaint against one person and not file it against others, you must have a credible explanation to do so. I'm afraid the complainant did not have any such explanation. It's really for him to answer this question, but all we said was that there was selective targeting of Priya Ramani.
Thank you for clarifying that. It feels a little bit discriminatory.
Yes.
It is, and I completely agree, because the kind of allegations they were from the other complainants in this were absolutely, they were egregious, and there was absolutely no reason I saw for him not to have pursued. But Rebecca, while I was going through the judgment, Priya's testimony is of course very compelling, and it comes across, she comes across extremely credible. But I was just thinking from, as a student or somebody who's practicing criminal law, and I don't, in that area, don't you think it's, I found this strategy highly unusual. It's also risky to put an accused on the stand. And, you're such a seasoned criminal lawyer. So I was just wondering what went through your mind when you decided to put Priya on the stand.
Yes. Thank you for that question. And I think, there's been some misinformation about it. Let me clarify what the strategy was. Section 499 of the Indian Penal Code defines defamation. And while Priya always admitted that she had published the 3 tweets and an article in the Vogue, which was written a year earlier, where she had not named Mr. Akbar, but the first 4 paragraphs of that piece related to him. She had said that later on. When she came to court, she pleaded truth as a defense. As you know, Section 499 has 10 exceptions. The first exception is imputation of truth which public good requires to be made or published. Now, the first exception says that it is not defamation to impute anything which is true concerning any person if it is made for public good, that the imputation should be made or published. Whether or not it is for public good is a question of fact. Likewise, the ninth exception says it is not defamation to make an imputation on the character of another, provided that the imputation is made in good faith for the protection of the interests of the person making it, or for any other person, or for public good. Interlinked with exception 1 and 9 is exception 3, which says that it is not defamation to express in good faith any opinion whatever respecting the conduct of any person, touching any public question, and respecting his character so far as his character appears in that conduct and no further. Priya's defense from the first time she entered court in response to the notice or the charge against her framed by the court was that I plead not guilty to the charge. I claim truth as my defense made in public interest and for public good. So she specifically invoked exception 1, exception 9, interlinked with exception 3 to section 499. Now, when you invoke an exception, you are admitting that you have published this material, but you are saying it is not defamation for the reasons given in the 3 exceptions. I'll give you a simpler example. There is section 300 of the IPC, which talks of murder. One of the exceptions to murder is grave and sudden provocation. Now, the person pleading grave and sudden provocation has to first accept that he committed murder, and only then can he plead grave and sudden provocation, that I committed the act in these circumstances which amounted to grave and sudden provocation. That is an absolute defense. Likewise, if a person says he pleads self-defense, he must admit to the act for which he is charged, but then say, I did that act because I had the right to self-defense. So likewise, in defamation, there are a set of 10 exceptions which an individual can plead. Priya pleaded the first, 9th, and 3rd exception. Now, if you plead truth as your defense, made in public interest and for public good, then you have to prove that truth, because there is a section in the CRPC 105 which says whoever is pleading a statutory exception must prove it. Now, it wasn't enough for me to cross-examine the complainant and his witnesses and make a suggestion of the exception. It was also obligatory on our part to put Priya on the witness stand, where she testified on oath about what happened that evening in a hotel room when she had first gone for a job interview. So this strategy is unusual. Defense counsels largely do not encourage their clients to take the stand, because then they can be cross-examined and it can enter into troubled waters. However, when you are pleading an exception, it then becomes almost obligatory. I won't say it is absolutely necessary, but it becomes almost obligatory on the part of the person pleading that exception to take the stand. And that is why Priya Ramani came as a witness in her own defense. She was defense witness number 1. She pleaded her case. She explained her tweets. She talked of the incident. And as I said, the reason why she did that was because she wanted the court to understand the nature of her truth, why she made the disclosure, and to understand that sexual harassment at the workplace is a matter of public interest, and any disclosures made on a public platform must be viewed in the light of those exceptions.
So Rebecca, in a sense, what we're saying is that the fact, and tell me, like, just as a lay person, and I really want to know that the fact that somebody has taken the stand in these sort of circumstances, does that not in a sense also give you a sense of elation that this is even better acquittal than it would be where the accused has remained silent in a sense?
Absolutely, absolutely. So I think the evidence we led was extremely robust, and I think it speaks a lot for the courage of these women, that they did not shy behind any statutory defenses that they could have said, they could have taken, but said, yes, I made these tweets, I made these disclosures, and this is the reason why I did so. So. As I said, you have to understand this case in the context of the law of defamation, because there is a lot of there is, I won't say misinformation, but there is an oversimplified version which is going around. I would be failing in my duty if I say that every disclosure you make at any time in your life will protect you from prosecution. That's not what this verdict is about. This verdict has to be seen in the context of the case Priya Ramani fought, in the context of the evidence she produced, including her own evidence. And therefore, the court says at some point in the judgment, I believe DW1 to DW3, I believe they were speaking the truth. Therefore, I fulfilled the requirements requirements of the law in terms of proving the exception to Section 499 of the IPC.
Before I hand you back to Meeta and Sukirti, just one more question from me. In sexual harassment cases, Rebecca, you have the word of one person versus the word of another person, because most of these happen in closed rooms. But in Priya's case, you actually led other evidence.
Yes.
And what is, I'm trying to, just for our audience today, tell us what's that kind of corroborative evidence that you could have possibly led in this case?
Well, in this case, we led the evidence of another witness who Priya confided in way back in 1993. In fact, she was present, except for the brief period when Priya went in for the interview. She was there right up till
1993. You mean the actual incident?
Actual incident. She was there before and after the interview. But the connecting evidence was a WhatsApp message which she sent out to Priya the very day on which she made the disclosure on Twitter, saying that, I remember it like it was yesterday. And this was many, many days before the complaint was filed against Priya. And the spontaneity of the message, and the original message was exhibited in court, was, of course, corroborative evidence. But in answer to your question, women sometimes don't have corroborative evidence. That is entirely true. I don't necessarily think that should be a reason to disbelieve a woman just because she does not have corroborative evidence. It is the nature of testimony. When a witness takes the stand, the honesty of her testimony can be determined by a court. So it's not always that the court looks for corroboration. We had corroborative material in this case, and so we put it up. But even if there is a compelling testimony from a witness who is accusing someone of sexual harassment or even a sexual assault, that testimony should be sufficient. As you know, in cases of rape, the Supreme Court has said, even if there is no medical corroboration, but the evidence of the survivor is of a compelling nature, the evidence of the survivor is of a sterling quality, we don't need corroboration. So this is also not entirely true. This is a bit of a misnomer that unless you have corroborative evidence, nobody will believe you. It entirely depends on the nature of testimony that you make in a court, and the credibility attached to it. If you come out as an honest witness, and in the words of the Supreme Court, a witness of sterling quality, you don't need to produce corroborative evidence.
You answered half my question that if you don't have evidence, what do you do? But actually, again, I'm speaking from a normal perspective of normal women, that you face some kind of harassment at workplaces or anything, and you don't have evidence. If you have evidence also, you don't know how to move ahead. So what should one do about it?
So as you know, the 2013 Act relating to sexual harassment in the workplace, Prohibition Prevention Act, actually gives you an alternative mechanism to access, not necessarily the criminal law mechanism, the alternative mechanism being that you go to the institution you're working in with a complaint against the person who has harassed you. And then an internal complaints committee is set up, and the internal complaints committee will view your evidence. Now, the evidentiary standards employed by the internal complaints committee are nowhere near the evidentiary standards that are required to prove or disprove a criminal case. Clearly, again, I want to highlight that corroboration is not a requirement even of law, much less of bodies like the internal complaints committee. If you have corroboration, give it. But if you don't have corroboration, it should not inhibit a woman from making a complaint against the perpetrator of a crime. It should only, the only requirement is that her evidence must be forthright, the evidence must be truthful, the evidence must be natural. And so this obsession with corroborative evidence should actually not be there at all, because everyone recognizes the fact that many of these crimes are committed within the confines of a room, and there very often is not corroborative evidence.
Rebecca, so you've spoken about the criminal law and the internal complaints committee, which would fall within the civil jurisdiction in a sense. And that brings me to my next question. The judgment deals with this, the burden of proof, yes, which is, and you argued this beautifully, which is the difference you highlighted between proving a case beyond reasonable doubt and proving the case on preponderance of probability. So you've spoken about in a criminal matter, the complainant has to prove his case beyond a reasonable doubt. But when the onus shifts on the accused, then in her case, she had to prove it on a preponderance of probability, which is really within the domain of civil jurisdiction. Yeah. Right. So, and then it then shifts back onto the complainant, yes, to prove their case beyond a reasonable doubt. So, for those that have non-legal backgrounds, explain to us what is the difference between these two standards of proof. And for our young lawyers, I mean, how did you use this tool so effectively in this judgment?
So in any criminal case, not just defamation cases, in any criminal case, it is the onus is always on the prosecuting side to prove their case. That's the law in India. That is the fundamental basis of our criminal jurisprudence, that the prosecution must prove its case beyond reasonable doubt. And if they don't prove their case beyond reasonable doubt, even if there are gaps in the story of the accused, it does not matter. The onus never shifts. That is one. But in cases where, like in defamation, where there is a specific exception which you are pleading, if you're pleading an exception, now the exception in 499 are specific statutory exceptions, but there are general exceptions like insanity, like many other exceptions. If you are pleading an exception, as I said, section 105 then says that the onus shifts to you, that you must prove your defense. If you take the plea of alibi, right, in a case, I was not even there when this incident took place, then the onus is on you to prove that alibi. But again, Indian law, particularly defamation law, recognizes the fact that where you are claiming an exception, where you're pleading an exception, the standard of proof is not the standard that the prosecution is asked to prove. The standard is one step lower, or maybe a couple of steps lower. They always must meet the test of proof beyond reasonable doubt. And accused, even if he's taking the benefit of a statutory exception, the standard is one of preponderance of probability. In fact, there are judgments which say the standards must be that of a reasonable person. that will a reasonable person believe what you're saying? It's not proof beyond reasonable doubt. So every element does not have to be proved beyond reasonable doubt. So the law on defamation, in fact, there are constitution bench judgments of the Supreme Court of India of the 60s and the 70s, which clearly lays down this test on defamation law, which says that if the accused is pleading one of the exceptions to Section 499, the only standard they need to cross is one of preponderance of probability and not proof beyond reasonable doubt. Once the court finds that they've crossed that standard, it will go back to the complaining side and say, now you prove your case beyond reasonable doubt. So this is what I had argued, but it wasn't an ingenuous argument. It was something which is the law laid down. These are extracted from judgments of the Supreme Court. There's a full bench judgment, a beautifully written judgment of the Allahabad High Court. These were the judgments we relied upon. And therefore, I said that while the onus is on them to prove their case beyond reasonable doubt, I have pleaded a statutory exception, and I have produced evidence to further the claim of the exceptions I have pleaded, and I have proved. Now, the standard of proof that the court has to take into account is only one of preponderance of probability and not proof beyond reasonable doubt. So I suspect I came very close to proving my case beyond reasonable doubt.
A lot of us are wondering, and a lot of viewers are wondering, that why was this case filed? Do you see that the filing of this case was a tool to stop the Me Too movement in India? And the judgment, of course, a lot of us have hailed it as a victory and a win for the movement. I mean, what was the reason behind it? Because it seemed like, we haven't seen a case of this magnitude for defamation, or at least in the public limelight.
So again, this was one of the defenses that Priya Ramani took in her statement to court, where she said filing of the case has a rippling, chilling effect on women. It silences women from speaking against any perpetrator of a crime, and it was to stop women from making further disclosures that she was made an example of, and a case against her was selectively filed. She has said that in her evidence. Why did they file a case? I'm the wrong person to ask that question. It is for them to answer. But yes, these are the whole Me Too movement, or for that matter, any disclosure that a woman makes against a male perpetrator is because she's speaking truth to power. Right? There is in workplaces, there is a power hierarchy. And when men seek to make workplaces less safe and to commit offenses of this nature, and women make these disclosures, they are speaking truth to power. So in that sense, Priya's defense, the larger defense of the Me Too movement, which was that, we've suffered enough. We've suffered for years and years and years on end. And this is a platform which is safe, where we can make these disclosures. In some sense, it was also a realization that perhaps our legal systems had failed women over the years. Don't ever forget the story of Bhavri Devi, a woman in Rajasthan who was the reason why we got the Vishaka judgment in 1997, whose case has not yet been heard in the High Court of Rajasthan, although so many decades have passed and many of her perpetrators are now no longer alive. These are the women on whose shoulders we stand generations after them. Never forget the story of Mathura, a young tribal woman who was raped in a police station by 2 policemen, and whose story was not believed by the Supreme Court in the 70s, because the Supreme Court felt that she had not voiced her resistance loud enough. She had submitted to the act of rape, and that submission was treated as consent. How much has changed since then? It led to the first amendments of the 1980s, and then we had periodical amendments, finally the amendments of 2013 after Nirbhaya. So I think these moments must be not viewed in isolation, but must be viewed in the context of a journey that women have gone through, a long, painful journey where women have lost, where women have been condemned, but then a realization comes that what has happened is wrong. Don't forget that against the Mathura judgment, 5 law professors of Delhi University wrote that open letter, that iconic open letter to the Supreme Court, where they pleaded that submission, my lords, is not consent. And that led to the 83 amendments. So all of these movements have to be seen contextually. And it can only give rise to the realization that women want safer workplaces. Women want the guarantees of equality, which are guaranteed under our constitution, to be a reality and not something which is there in the Constitution of India, but never implemented.
Thank you for clarifying that.
So again, Rebecca, you answered half my question that how the change, the shift is happening. But in other countries, when Me Too movement happened, the whole country united, there was a lot of campaign and you knew that the change is happening. So the challenge in our country, is it because of the justice system? It is because of our culture, but we still, as you said, we still are failing women.
Yes and no. I wouldn't like to underestimate the achievements of the legal system or India in general. I mean, don't forget that in 2012, when the horrific gang rape in Delhi took place, this city saw an entirely peaceful movement against what had happened. And that led to the setting up of the Verma Commission, and then finally led to the amendments in the law. So I wouldn't say that that we've not had successes in our struggle. I wouldn't say. I think in the past, the legislature and the executive has listened to the voices of women. Of course, it's just never enough because of the scale of crime against women that takes place in India. But all over the world, there is a general pushback when women speak out. Let's not forget the case of the IMF chairman who had sexually harassed and assaulted an employee in the hotel, and the entire system was geared to falsify her testimony. She was an immigrant from Africa. She had all manner of baggages, which was what was projected. So I don't think it is peculiar to India. I think it's peculiar to, it is something which is common all across the world. When you take on powerful people, there is going to be a pushback.
In the same context, sorry, go ahead, Meeta. I'm so sorry.
No, I was just kind of saying that I agree with it, that it's a power play and yes, changes are happening.
Yes,
that's true. We've had the case of Brett Kavanaugh being, elevated yes, to the Supreme Court. Yeah. So, Rebecca, tell me, from the context of the court, and there have been judgments saying that you have to be careful of the manner in which you question women. But we know the kind of question, the prosecution in this particular case, but usually it's the defense. That is capable of the kind of questioning that they will do for women victims. We've also known of cases where there's heckling in court when a woman victim is giving her testimony. How do we deal with this? And also, is it not, and I get it that, as part of your strategy, you might want to rattle the witness. But at the same time, even if we as defense counsel or prosecution are asking questions of this nature or heckling the witness, are we not then, in a sense, playing into the entire cycle of misogyny? And you're preventing women from taking the stand.
It's not very difficult. I don't know why we can't be respectful of people who we are again, of the other side. I'll give you a small example, something I saw when I was a very junior member of the bar. I had gone to one of our district courts, and I happened to step into a court where one of the iconic trial lawyers of Delhi was conducting a trial. I think it was a dowry death case. I'm not entirely sure. It was not my case, but I happened to watch him. I knew him personally. And at some stage, when he was questioning the mother of the deceased, she broke down. And she broke down in a way that she began asking the cross-examiner, what if it was your daughter? You're asking me all these questions. And she had this moment where she began crying in court. I won't name the cross-examiner, except that he was one of the most brilliant trial lawyers I've had the privilege of watching. He stepped back and went and sat down on his seat and allowed her to compose herself and allowed her to cry. She was actually accusing him of insensitivity in the manner in which he was questioning her. And later on, once the matter was over, I recall him telling his junior, she's the mother of the victim. She's the mother of the deceased girl. She has every right to break down in court, and she has every right to accuse me of asking questions that are painful to her. I'm doing my job. I have to do that job as a defense lawyer. It was a very important lesson to learn for a young lawyer. I learned that lesson, that adversarial spaces can also be respectful spaces. And while our court system, criminal law is entire, especially our trials, are entirely adversarial, but we can be respectful of the person opposing us, both as counsels as well as with respect to witnesses who take the stand. I, unfortunately, am seeing far too many women survivors being pushed and them being attacked in a way which has nothing to do with the facts of the case, nothing to do with the testimony, but simply slut shaming, heckling, and making her feel entirely humiliated by this process. And time and again, the Supreme Court reminds us, do not do that. Be careful. Ask your questions in a respectful way. There are amendments to the law post 2013, which says you cannot attack or you cannot bring into play the past sexual history of a woman survivor. And yet we see in court after court across the country where this is actually the only basis of questioning. And I wonder why courts don't come down more heavily on women survivors. This is not I'm not for a minute suggesting that the person in the dock, the person accused of a crime, has no right to a defense, not at all. As a criminal lawyer, as a defense lawyer, as a person who believes intrinsically in constitutional protections, I believe that the person who is accused of any crime has every right to prove his or her innocence. That is a constitutional right. But while doing so, you do not have to resort to tactics which are demeaning. And I wish we have a space which can be adversarial, but more respectful.
Now, coming to the question of criminal law, unfortunately, I think this is a space that is still mostly dominated by men. And as a woman, as you've said, the courtroom sometimes could be a very harsh space. How do you cope?
I've been around for far too long. I don't think it's, I think, my 34th year of practice. So in the beginning, I was viewed with amusement. What is this woman doing in a space which is essentially a male space? Each one of us have gone through our own struggles. And at that time, and Payal will know this, she will understand what I'm saying, both as a woman as well as a practitioner of the law. Initially, your entire concentration is, please take me seriously. I know what I'm talking about. Most of the time, we don't know what we are talking about because we are so junior in the profession, so we don't even know whether we are making the right submissions. But as you go on, and I will say that my peers accepted me for who I was. I don't think I found them to be particularly critical of the fact that I'm a woman and therefore I'm in a different space. But it's been a long journey. Today, I don't care. You can look at me in whichever way you want to. I know the law. I know what I'm doing, and therefore it's easy for me to stand up to any kind of nonsense. But I recognize the fact that younger women uh, uh, always find it that much more difficult, even though there are so many young women in our profession today. You just have to come to our bar rooms. Of course, we haven't had access to them for over a year, or our canteens, and you see the place full of women, young women, vibrant women. It's such a sight for sore eyes. It's wonderful seeing it. And who confidently argue in courts. I can, Payal heads a chamber full of women. I have a couple of men in my office, but largely and increasingly, I get more applications for young women juniors to join me. I think it's a great way to celebrate the particular field of law that I practice. Women are not in the least bit intimidated by the nature of, people keep asking me, but you deal with criminals. And I say I deal with people who are in dark spaces. I don't want to label them as anybody as criminals because I am not in the position in which they were when they committed the crime. It's very easy for us to be judgmental, but who am I to judge? So whoever comes to me, be it from the prosecuting side or from the defense side, are people who are in a very, very painfully dark space and are reaching out for help. And therefore, criminal law, in a peculiar way, has taught me, and I hope people who have walked the journey with me, compassion. It teaches you never to judge. It teaches you to deal with every individual in a compassionate way, in a humane way. And I think what women do to this profession and to this area of law is to humanize the space, is to feminize the space, and that can only be an achievement.
Thank you.
Rebecca, with this question, I'm very curious to know. So you, in a sense, you're a defense counsel. And, for non-lawyers, they'll always see this as a defense counsel is somebody who's labeled to be fighting for the bad people or the wrong side. And, it's hard to explain to them that it's a constitutional right. We as lawyers we have a duty to defend every client in the same robust manner as we would to the so-called perceived innocent. But particularly you, Rebecca, and I've seen your journey over the past at least 25 years of being in the profession, me being in the profession, and you've been there longer, but you've managed to create this balance where within legal circles, you're known for your humanity, for somebody who's fighting the right causes, for somebody who's gone beyond her call of duty so many times. How has this balance been achieved?
So Payal, have appeared for all manner of people. It's not every fight is for a cause, right? But just answering the first part of your question, I have never felt this chaos in my mind, or who are you appearing for? What crime have they committed? As lawyers, we know that we have to represent people. Some of their crimes are horrendous, but they are still entitled to a defense. If you recall, in early 2020, just before the lockdown, I appeared for one of the men about to be hanged in the Nirbhaya case. I appeared for him in the journey between mercy petition and execution, because there are so many constitutional challenges during that journey which must be upheld. India has some of the finest jurisprudence with respect to that journey, just around the time that a death row prisoner files a mercy petition till his execution. and to ensure that those rights are fully given to a man who's about to be executed. I was asked to appear for one of the men who was on death row, and I did, because I think senior people must make sure that before you take someone's life, every constitutional protection envisaged by the law is given to that person. I don't find myself conflicted by any of these moral dilemmas ever. I don't find it was the right thing to do, and I began my arguments in court by saying I am not challenging his conviction. I am not for a minute saying that what he did was right, but I am saying we have crossed that stage. Now is a stage where you're about to execute him. Please ensure that these constitutional guarantees are given to him before you execute. The Supreme Court says that those constitutional guarantees are available till the last breath of a person's life. So I am inspired by our Constitution. I work within the four corners of the Constitution. I don't really care what the allegations are or what people think of a particular person. My clients don't have to be popular, or the persons I appear for don't necessarily have, are not always innocent. I don't know. Who am I to judge? But if there are protections available in law, those protections must be given. So I don't think, I know there's this big debate outside. Oh, how could you appear for that criminal? How could you do this? How could you do that? No, as I said, I don't go through any of those dilemmas. It is our duty as lawyers to appear. And if you don't give representation to people, then I think you are violating both the Constitution as well as the Advocates Act under which we all operate. But as I said, we can humanize the space. We can make that space. And it's not like I haven't fought tooth and nail, or I'm any less aggressive than my male opponent. It's just that when you can do that in a respectful way. You do not have to do that in a contemptuous way. You do not have to do that in a humiliating way. You can be respectful while you fight tooth and nail for your client.
Rebecca, having known you, I can say this with my hand on my heart. I know you're somebody who's found that balance just absolutely beautifully.
Thank you, Payal. Thank you so much.
But just coming back to Priya's case, it was interesting that when Mr. Akbar sued Priya, instead of being cowed down, women actually doubled down in a sense, because there was this lady who accused him and wrote an article in the Washington Post that had become very, very controversial. He said it was a consensual relationship. She came back with a powerful thing saying that, no, it was coercion and abuse of power. But what I'm interested in is not that controversy, but you actually used this article. You confronted him with it when he took the stand, and it was in the context of his character. What is it that you asked him? In what manner was this evidence used, and what was the relevancy of this article to the defamation case?
So you see, one of the important ingredients of defamation is reputation. Right? When you are publishing or voicing an opinion, which is in the nature of an imputation, it has a direct link, or at least the section says it is causing harm to a person's reputation. It of course presupposes, and the entire case of the complainant was that he was a man of sterling reputation. I was very mindful of the fact that I should remain focused. And I at the time when I was cross-examining him, I was also very clear that Priya would be taking the stand. I knew who my witnesses were going to be, and they were just structured, just 3 witnesses. But while cross-examining him, I made use of some of his own disclosures, where he made public statements to the ANI, where he said this was a consensual relationship. My cross-examination was very simple. In fact, it ended in 3 lines where I asked him what her age was. She was only 23. What his age was. It was double her age. I asked him whether she was a subordinate at the workplace. Now, if you are at a subordinate at the workplace, and this is the power differential, the inferences that can be drawn from that cross-examination is self-evident. So I was using that only for purposes of contesting the argument of the other side that the complainant was a person of sterling reputation.
Very interesting.
So now I have a question, because, litigations, they are very, very hard emotionally and financially. Is there any redressal mechanism available for Priya to recover at least the legal cost? And in some cases, because this case was so high profile and it got so much media attention, for common girls, especially underprivileged girls, how should they go about this?
I think Priya is just immensely relieved it's over, and I don't think she's interested in taking any further recourse to any law. Nor do we have a robust system where acquitted persons are entitled to compensation. This becomes even more meaningful when people from less privileged backgrounds are forced into the legal system. How do they pay for, and even if you have a lawyer who is not necessarily charging his or her fee, the sheer costs in terms of reaching the court, spending, imagine somebody who's a daily wage laborer has to leave her job for a day and come and remain in court. Our systems are such that very rarely does it end with one appearance. She has to come multiple times. These are problems that the Indian legal system face. We have found no solutions for it, and that is perhaps one of the reasons why, although it was a purely urban, upper middle class movement, the Me Too movement, it didn't touch the large majority of Indian women who are part of the unorganized sector, who are poor and vulnerable. Yet I think the Me Too movement was an expression of frustration with our legal system, with the fact that women have not had a very easy journey inside courts. Imagine how much worse it is for those people who can't access lawyers, who don't have money to fight their cases, who are part of a system which treats them like the furniture in a courtroom. It is very, very difficult. And I think while we celebrate this verdict, we must always be mindful of the fact that women less privileged than Priya Ramani are going to court with none of these privileges at their command. And we must be equally respectful of those struggles and reach out to as many women as possible. It is impossible for a few lawyers sitting in our big cities to do that, but this is a problem which exists across the country. And as you go deeper into districts and towns and villages, we see women literally helpless and not having the means or access to lawyers that they should have to fight their cases.
Yeah, it is a big challenge that we are facing.
Yes.
But as we said, the change is happening. So it's a milestone judgment, and the judgment is 92-page judgment. Isn't it 92 pages judgment? No.
Yeah.
So
yes,
a milestone judgment.
pages. Yes.
Yeah. So the court had some powerful words on sexual abuse and sexual harassment in this judgment. Can you please tell us, because what was those significant judgment which was everybody should know, which brought the change?
Yes. So again, I will say this is in the context. These observations made at the end of the judgment was in the context of the public interest argument that raising one's voice against sexual harassment or making a disclosure about sexual harassment at the workplace is a matter of public interest and public good. And it is in that context that the court has, and I'll quote from the judgment, where the court has said, the accused also contended that there was no mechanism at the time of incident to redress sexual harassment at the workplace committed against her by the complainant. And later on, she chose not to file any complaint against the complainant, considering his powerful social position and status. It is also contended by the accused DW3 did not lodge the complaint against the complainant, considering his social status, powerful position of the complainant, social circumstances, and she opted to remain silent to avoid social stigma attached with sexual harassment. The accused contended that various other women who were subordinate, who worked with the complainant, also disclosed sexual harassment committed against them by the complainant, and the same found mentioned in the document proved by the complainant, Exhibit CW 1/14. However, the complainant selectively chose Priya Ramani and filed the case of criminal defamation against her. And then it goes on to say that the time has come for our society to understand the sexual abuse and sexual harassment and its implications on victims. Society should understand that an abusive person is just like the rest of other people, and he too has family and friends. He shall also be well-respected person of society. Victims of sexual abuse not even speak a word about abuse for many years, because sometimes she herself has no idea that she's a victim of abuse. The victim may keep believing that she is at fault, and the victim may live with that shame for years or for decades. Most of the women who suffer abuse do not speak up about it or against it for the simple reason of the social stigma attached with sexual harassment and abuse. Sexual abuse, if committed against women, takes away her dignity and her self-confidence. The attack on the character of the sex abuser or offender by sexually abusing the victim is a reaction of self-defense after the mental trauma suffered by the victim regarding the shame attached with the crime. The woman cannot be punished for raising voices against the abuse on the pretext of criminal complaint of defamation, as the right of reputation cannot be protected at the cost of right of life and dignity of a woman, as guaranteed under the Indian Constitution, Article 21, and the right to equality before law and equal protection of law, as guaranteed under Article 14 of the Constitution. The woman has a right to put her grievances on any platform of her choice, and even after decades.
Very powerful.
Extremely, extremely powerful. And I remember when the judgment came out, I mean, I remember we were actually sending out celebratory messages to each other. It felt like almost a personal victory for each and every woman, you know, so it was something that was incredibly, incredibly personal. And so we thank you so much for sharing these thoughts with us, because it's encouraging to see that, yes, the Me Too movement, that we can actually speak out, that our voices do matter. But in closing, is there anything else that you would like to tell the women that are watching?
I think it was a deeply empowering case, even for us. You know, I may have been the face of the legal team, but I was supported by an incredible team of colleagues who worked day and night on this case. And for each one of us, speaking on their behalf as well, I think it was a privilege to be part of this journey, because we learned something which was so deep. I mean, we were able to empathize with something which was so deeply personal. I may be a criminal lawyer, but it's not like we haven't faced sexual abuse. It's not like we haven't been groped. It's not like incidents of this kind have not happened in our lives. So it deeply resonates with every woman. And I think that's the reason why this judgment found so many women celebrating it. Because it was so deeply personal. Priya Ramani may have been the face of this struggle, but almost every woman who has faced sexual violence of some kind or the other can empathize with what she went through and with the fact that she was asked to defend herself in a criminal defamation case.
So from all the women that are watching you, from all of us, a big thank you also for us, because it was not only Priya Ramani's voice, but I think we all feel a part of our voices that also got heard. That
I may also add, just one more thing. I may also add that besides Priya, there were two other incredible women who did not have to take the stand, but chose to take the stand. One corroborating Priya's story, and the other coming out so bravely and in speaking about her own personal experience. I also saw so many women and many men who came to court in support of in support of Priya Ramani. It was altogether a deeply, deeply empowering moment, even for us lawyers. And so I really think we must recognize the contribution of each and every person in a case like this, including the women who stood by Priya throughout the trial, who came to court and testified bravely. So this is a victory for each one of them.
Well, thank you so much.
It's calls for an applaud.
Thank you very much.
Thank you all for joining us today. I know everybody is saying it's a pleasure to hear you. The judgment brings hope. Thank you is all the messages that I'm reading. So I'm just reiterating that. And I think this was a perfect way for us at least to end a Saturday with that ray of hope that is all in our hearts.
Absolutely. Thank you. Thank you very much.
Thanks, Rebecca. Thanks.
Thank you, Payal. Thank you so much.